Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about patent process and patent strategy. And this really covers the basic concept of where you're going with a patent application. What we plan to do is I plan to walk you through the whole process of getting a patent. The first stage is to get a provisional patent. And now a provisional patent in Australia lasts 12 months. At the end of the 12 months, you then have to make your mind up as to whether you're going into individual countries or whether you want to go into an international application called a PCT application. A PCT application is what most applicants choose. And the reason is because it leaves the door open for you to choose multiple countries after you enter PCT. If you go the other way, you're locked into the decision as to whatever countries you make. So if you only pick USA and Europe, you can't pick China at a later stage. So generally people pick PCT as it buys them a bit more time. So the PCT process is run by an organisation called WIPO, which is part of the UN. WIPO administers this PCT process and they do an examination on your application, and it proceeds just like a normal application in a single country. The differences are, though, is you don't have to explain your case to the examiner. So the examiner will give you an examination report. You don't have to argue with him if you don't want to. In some cases, it's not in your interest to argue with the PCT examiner. Once you get past the examination process, you then have to enter each individual country. So you still have to make that decision as to which countries that you want to go into. And this is called the national phase entry stage. When you pick those countries, you still have to abide by the laws in those countries, which means that there will be an examiner in each country, and that examiner will look at your invention to work out whether it's novel and inventive. And he also has the benefit of looking at the PCT examiner's report and using that as the basis for his. In the US, quite often the US examiners have a lot more experience than the PCT examiners, so they usually do their own searches and usually come to their own conclusions. But in most other countries, they do follow generally what the PCT examiner says. Once it enters this national phase period, it usually takes about 2 to 3 years to get through the examination process. And then once you've gone through the examination process, it's granted. Once it's granted, you can then enforce your legal rights under the patent right back to the original provisional filing date, if it's been done correctly. Which means that you can retrospectively sue people for your right, even though it was patent pending through that entire process. And quite often you'll see products on the market that talk about a product being patent pending, and that's exactly what it means. It means it's somewhere between the provisional stage and the granted stage. But once it's granted, it's a patent granted, and it'll actually have a formal patent number. And generally people put that on their products, makes it more enforceable. And then if you ever want to enforce that right, you can then take it to court in the respective jurisdiction. So basically, that's an overview of what the patent process is about. It generally takes about 5 years to get a patent granted in most countries, although there are some tricks of the trade to speed up the process if needed, if you think there's an infringer in place. But we generally take our time because it spreads the costs out over a longer period. It costs the same amount, it just takes longer. I hope this helps. And if you have any more queries about the patent process or patents in general, please feel free to contact myself, Anthony Alder, or Alder IP. Thanks for listening.